Well, good evening, ladies and gentlemen, other distinguished guests. My name is Dr. Kathy Liddell, and I'm the director of the Law Faculty's Centre for Law, Medicine and Life Sciences. And it's on behalf of our centre and the Cambridge Science Festival that I'm delighted to welcome you to this 2019 Baron de Lancey Lecture. Knowing some of you who are here as you came in through the doors, I am confident that we've been joined by people with a wide variety of backgrounds. Lawyers, naturally, but also some doctors, philosophers, students, and members of the public. And I can tell you that this diversity is fantastic and just what we hoped for. I also am sure that we share something in common relevant to this lecture. No doubt many of you are parents, and I know as a sure fact that all of you have been vulnerable children at some stage. So we are very fortunate and grateful that the lecture series is funded by the university's Heyden de Lancey Fund, which exists to support medical law research and teaching. The fund was bestowed by a foundation in Jersey, which was set up in 1970 in memory of Baron Heyden de Lancey. And we are delighted that two trustees from the foundation are here tonight, Dr. Charlotte Ritter and Dr. Bas van Ugelkak. Dr. Ritter, I hope she doesn't mind me saying, is a descendant of the Baron's wife. And I've had the pleasure of learning more about the Baron through her and her husband. The Baron was, by any account, a flamboyant and extraordinary Dutchman. He was at various stages of his career a doctor, a dentist, a high finance lawyer, and an art collector. So clearly a curious and intellectually agile person. He became not only a baron, but also a public benefactor. And long story short, here we are benefiting from his endeavours. So as we are a relatively new centre, this is the third year that we've had the opportunity to organise the Baron's Lecture. But the series has had a long history of distinguished speakers. I won't give you the full list, but just by way of example, the first Baron de Lancey Lecture that I personally attended was given by Dame Elizabeth Butler Sloss, who was then the president of the Family Division of the Court of Appeal. And she talked about several court decisions affecting the beginning and the end of life. And other lectures have traversed everything in between. So in 2016, for example, we had a QC speak about informed consent and medical negligence. In 2011, the topic was pharmaceutical regulation. And last year, Professor Glenn Cohen from Harvard Law School discussed emerging reproductive technologies. Tonight, our subject is medical decisions for young children. In particular, the role of their parents, the courts and doctors when there is a disagreement about the child's best interests. So cases involving Charlie Gard, Alfie Evans, and Aisha King brought this issue to the nation's attention. We are very pleased that our friend and distinguished academic, Associate Professor Imogen Goold, has agreed to give the lecture. Imogen comes from that other great English faculty of law, the one who must not be named. And if you're thinking that it's the University of Voldemort, it's the other one. At that place, you know where, Imogen specializes in medical law. She has written some terrific books. I've brought a small prop, just a couple of them here. And she has a real talent for unpacking controversial debates in medical law with rigor and insight, and proving that this particular book we like very much It's called Great Debates in Medical Law and Ethics. And I think that that is certainly what we're going to witness tonight. So Imogen, the floor is yours.
Thank you, Kathy, and thank you also to Jeff and to the Baron de Lancey Foundation for having me. I'm very honoured to be here in what we call the other place, back where I'm from. So I'm going to talk to you today about issues around parents having the final say on the medical treatment of their children. My work today is based on a paper I've been writing with Dr. Cressida Auckland of the London School of Economics. And it's also the topic of a wider project, a forthcoming edited collection of essays about this question. So what am I going to talk to you about today? Well, over the past few years, the English courts have been called upon to grapple with a question that actually seemed quite well settled in English law. And that was who should have the final say over the treatment of a very ill child. Now, we're concerned with cases today where the child is very young. So we don't mean Gillick competent children, we mean children who are too young to express their own wishes. And so therefore they can't express meaningful views and someone else therefore needs to speak on their behalf. And these are cases as well where there are conflicts. So conflicts between the treating team and the parents. So the cases like Charlie Gard, Alfie Evans, Isaiah Hastrup, these are the sorts of cases that I mean to speak about this evening. Now I imagine that we're all very familiar with these cases, and the reason is that they dominated the headlines of the newspapers over the past three or four years. But I'll tell you a little bit for those of you who are not particularly clear on what happened in them, to give you a sense. And they are very fraught, and I think people have a lot of opinions about what went on in those cases, and I shall try to be relatively factual and fairly simple. But there's certainly debate about the facts as well as what should have been done. So with Alfie Evans and Isaiah Hastrup, the key issue was that his parents, each child's parents, wanted sustaining care to continue. And they wanted it not, well, particularly in Alfie's case, to extend his life a little bit. It's unclear how much they believed he might get better, but the key thing was to extend his life a little bit. With Charlie Gard, the situation was somewhat different. And as many of you will know, in that case, an American doctor offered an experimental treatment, which the parents wanted to take. They wanted to take Charlie to the United States where he could have this treatment in the hopes that it would work, even though it hadn't worked in any case like his before. But they constructed this as, there's a tiny chance we should take it. However, Great Ormond Street Hospital was concerned that it wasn't in Charlie's best interests. And this was the issue the court explored. Was it in his best interests to travel to the United States and have this small chance, if it was even a real chance? You might consider it futile, you might not. And that is a matter of some debate. But the other thing on the other side was, it was potentially harming for him to travel. That it would have been distressing potentially, and because they couldn't fully tell how much he was experiencing. So it wasn't a simple thing to take him to the United States. And this is very much what that litigation was about exploring. Now, the courts have made it clear that they have the power to make medical decisions, or at least authorised decisions, at the point at which a child's welfare is engaged. So that is the threshold point. And all the courts affirmed in these cases that this was the position they would take. So what I'm going to call the orthodox position. It's often referred to as the best interest approach, but we also talk about it in terms of welfare. We should see these as synonymous. But what's happening here is the courts are stepping in the case of a dispute where either the hospital or parents have asked for leave to have it decided, and they approach the issue from the perspective of the child's best interests. And so my concern here today, or the thing that I'm interested in talking to you about, is not whether best interest is the right approach so much, but rather what is the point at which courts can involve themselves in these kinds of disputes, because that's the key interesting and essentially new issue that comes up in the Gard litigation. So what this boils down to, the issues that surround these cases are, who should have the final say? And there's actually three parties, you might say, might have the final say about what is to be done. You could say it is the courts, which is the orthodoxy. You could say it's the doctors, and then in fact the courts couldn't override doctors. Or you could say it's the parents. And the subsidiary question to this is, what is the point at which the court would have authority to intervene? Is it when welfare is engaged, as it currently is, or is it some other threshold? And that's the challenge that was made in the Gard case. Now you might wonder, why is this a live issue? The courts have had a say at every level. We've had a clear answer to this question. So the Court of Appeal and the Supreme Court confirmed the orthodox position in Goold and in Evans that the court can intervene when the child's welfare is engaged. But actually, there's a number of reasons why we might think that this is a live question that needs attention. And one of those is the public reaction to these cases. So there were outpourings from some quarters of the public with the belief that parents should have the final say. So these are a few examples of the sorts of things people had to say. So no matter how skilled the doctors, this wasn't their decision to make. They should have recommended a course, but they should never have felt it was their right to impose their wishes over those of parents. Charlie Gould's father, Chris, said, our parental rights have been stripped away. And that notion of rights is one we'll come back to. Another comment, when it's a child, doctors and judges can play the God role and leave the parents powerless. So there's a real sense in some of the comments about this case that the parents here were being disempowered, that of anybody who should speak, it was them. And in response to the situation, both Charlie's parents and Alfie's parents have moved for changes to the law. So what is called Alfie's law and also Charlie's law. And one key dimension of these proposals is that they would shift to what we would call a harm threshold, that parents will have the prima facie first say, and in fact that won't yield unless their decision is likely to cause significant harm to the child. So a much higher threshold before courts can intervene. That's what they're proposing. Now, so far, these efforts to change law have been unsuccessful, but it doesn't mean that they've stopped in their challenge. So that's one part of it. But public concern about the law isn't the only reason, and it possibly isn't a good enough reason in and of itself to simply say we should change the law. And I don't think it is the only issue here. So there's also the legal question. Now, in one sense, the law on best interest has been well settled for a long time. So the courts have for a long time taken the best interest approach, and they have in the course of that, I think, developed a nuanced, considered, thoughtful, sensitive approach to dealing with these kinds of cases. There are numerous cases in which we see that the courts have worked out how will we determine what is in the best interest of a child. And I think there are many judicial statements in which they demonstrate a great deal of sensitivity to the place of parents. It simply isn't the case that the courts come in and stomp all over what the parents want. That isn't how it works at all. It's quite the opposite, in fact. But I think the interesting question is the one that is raised in Goold, is the point at which the courts can in fact step into a situation. And so this is what was proposed in the Goold case in the Court of Appeal, where they say, well, actually, the way we should approach these, the point at which the court should be able to intervene is in fact when the parents might do harm. And other than that, we should leave parents free to discharge their responsibilities. So it's actually framed as when there's a possibility, when there's a serious risk that they will cause their child significant harm. Otherwise, parents make the final decisions. Now, in doing this, they drew on the language of the Children Act and the threshold for care proceedings and a care order to be made. But actually, this isn't a threshold that just derives from that. It's one that's been widely debated in the ethics literature, and it's in fact widely supported in the ethics literature on these kinds of cases. Now, there's reasons why the Goold case enabled this kind of challenge. Now, usually, the kinds of situations we're talking about are ones in which the parents are butting up against a treatment team, and the treatment team don't want to give the parents what they want. The parents don't have another option, so you have this conflict, parents versus treating team, and that's it. And so, in a sense, you have an impasse. No one can get any further. But actually, the Goold situation is different, and counsel in the Goold situation use this as a way to make their challenge. So in that situation, in actual fact, there was a choice between treating teams. So there was Great Ormond Street Hospital, and there was the American doctor, Dr. Hirano, who was offering the experimental treatment. So in this case, the parents didn't have the same kind of impasse. They weren't arguing with the doctors. What they were arguing was they wanted to be able to take Charlie to the United States for this treatment, at the point when Great Ormond Street wouldn't give them the treatment. And Great Ormond Street had reasons. So there's a complex story there that I won't go into. But Great Ormond Street had very good reasons for why they didn't want to do this. And they had, in fact, explored the possibility of this treatment. But then Charlie's condition had deteriorated to the point where they didn't feel that it was in his best interest even to try. So Great Ormond Street didn't think that Charlie should travel. And so the matter came to court because what the parents wanted to do was take him from the hospital and take him to the United States. So in that case, they framed this as, well, this isn't an impasse, but instead this is a matter where parents are taking a decision about the choice of treatment approach. Between two medical teams, they prefer Hirano's approach. And so that then enabled counsel in that case to say, well, this is a different sort of situation to our normal best interest. We don't need the court to come in to get past this impasse. And rather, instead, the court should stay out of this, because this is the matter for parental choice. Parents are allowed all the time to make different treatment decisions amongst a range of options that are put to them. The interesting thing about that is that this was a case where a medical team was putting an option on the table that another medical team was saying, we wouldn't put that option on the table. And so they're making a menu of choices in a sense. And the parents' argument or counsel's argument was they should be permitted to choose amongst these seemingly reasonable options. And we'll come back to that in a moment. But the third reason I think that this is a live question is that it actually demonstrated the breadth of the court's power to intervene. So usually what we're looking at is whether or not a treating team has to sustain care and how we will navigate that. But in both Evans and Goold, there was a bigger question, or a different question, which was whether or not these parents should be permitted to take their children outside the country. And would the court be permitted, did the court have authority to say to them, we will prevent you from doing that as well? So this is an extra question here. And it was a question that's probably familiar from cases like Usher King as well. But it's particularly a question in both Goold and Evans. Now, it was well established that the court could make declarations about what care the child could receive, but could they make this decision? And Lord Justice McFarlane in Goold said yes. He says it's if necessary, and one hopes it won't arise, but we could make an order backed up by an injunction to prevent the removal of the children. So what we see here is it's revealed, if it wasn't already apparent, that the court has very broad powers, very extensive powers. Now, the fourth reason I think that this is a live question and one we should think about is that there is very strong support for a move to a harm threshold in the ethics literature, and there has been for at least a decade. And I'm going to explore a number of the reasons why that is later on in this talk. So it isn't the case that simply because we have a judicial position on it, that this is a question that we should allow to drop. There are certainly people in our community who think that this is an area where the law should change. So I think that we need to give it really deep consideration. Now, normally when I give a paper, I come into that paper with a position and I want to argue for it. I want to convince you why I'm right. But I can't, unfortunately, do that for you today. So this is a situation in which I am conflicted. I don't know what I think completely. And this is funny because I've been thinking about this for about a year and a half now, and I still don't know what I think. So much so that my co-author and I have been debating it amongst ourselves for weeks. So much that this week I rang her up and I said, are we sure we think this? And she said, I've made my peace with it. And I said, I haven't quite made my peace. So I'm coming to you, and I'm very interested in your perspectives on this as someone who is not sure. In fact, we have most of our conversations when I put my own children to bed and I'm on my way to Tesco's to get some milk for the morning breakfast. So the regular customers of Abingdon Road Tesco's are well versed in the intricacies of the Goold decision and the various arguments on either side. And I'm sure they could all weigh in quite articulately at this stage. So why am I conflicted? Why can I not make up my mind? Why is it complex? Well, part of the reason is that there is space for reasonable disagreement about this. But the other reason is that there are multiple perspectives that we need to take account of and to understand these questions from those perspectives. So one of them is the realities of decision-making in medical settings. That when we take a position in the law, it has implications for how doctors and nurses and other staff in hospitals do their job and talk to parents. And they have their own perspective on the implications of how they have those conversations and how those conversations will be framed. And related to that is the dimension of medical professional conscience and what doctors are prepared to do, what they are happy with doing, and what the law will do in response to the decisions that they make. But there's also the realities of how the legal process works. It's very easy for me to sit in that other place and pontificate about what should happen. There's a gulf between that and the realities of day-to-day practice for the lawyers who are supporting both sides in this case, and also the judges who have to decide it. And there are practical realities of the way in which things play out in that process that have to be accounted for as well. So we might have a position which is ethically sound, philosophically justified. That doesn't necessarily mean that the law should map entirely onto that. And there are plenty of areas in which the law does not perfectly map onto ethics or philosophical positions for very good reasons. But there is also the impact on the parents and us as a community by the way in which the law is framed. And that is part of the concern that many of these parents had, which is they think that a signal is sent, that they are disempowered, that the court steps in and steps over what they see as their private space, the space that they think is where they have authority. And we need to be concerned with that. We need to think about what signal do we send to people? What impact does that signal have? These things are important. We see it in lots of judgments in medical law about the signals that we send. We see it in end-of-life decisions. We see it in decisions about wrongful life cases, that the law doesn't want to send signals that are harming. And I think that's right. It needs to be mindful of the language that it uses and the implications that language has. But there is here as well, and this is the part where there is interesting conflict, is there is a fundamental question raised by these situations about the right boundary to draw between the power of the state to involve itself in what you might consider private family decisions. And where should we draw that line? How far should we want to defend that privacy? And then on the other hand, how far the law should be stepping in to protect vulnerable parties. Because it's important to remember that there is a vulnerable, silent party in all of these cases, and that is the child. And the court has taken upon itself, and I think rightly, to protect that child. So we are navigating a tension there, a complex tension. And there are values at stake there: privacy, familial, protection of the family unit, but also protection of the vulnerable. And in this as well, and this is something I'll tease out a little later, is the question of how we protect plurality of values. How do we protect, in a democratic society, the fact that people feel differently about these questions? People have different opinions about what is right for a child in these situations. And there is space for legitimate disagreement about that people can all be right, in a sense, about what is the right thing to do. And so that is why it's a complex question. This is why I struggle to know precisely what I think. And the other thing I wanted to talk to you about before I go into some of the arguments on either side of what we should do is I think there's two things we should always keep in mind and when we're thinking about these cases and when we're developing our opinions about them, when we're holding forth about what should happen. And one of those is the nature of parental love, what it means to be a parent and to love. And I'm the parent of two small boys, so I know all about it. And I think parental love, like Michael Sandel, I think it's a very particular kind of love. You don't choose your children, and yet almost all of us love them no matter what. We don't love contingently. That isn't how parental love works. In fact, it's the opposite. It's one of the things that makes it powerful and important. And we love them with this depth and a passion that's really unmatched, I think, to many other things in our lives. I think parental love is primal and visceral. And I think nowhere else have we seen that more evidently recently, but in Goold and Evans. That's exactly what's going on. That's how these parents are feeling. And we need to understand how they're acting in these situations coming from that perspective, and that's true. And we need to respect that. And we need to take care in our language and be thoughtful and sensitive in the way that we frame the laws in response to them. However, there are other people in this situation who are fighting as well, who are trying desperately as well. And that's the medical teams. No one's ambivalent in these situations. No one doesn't care. No one is thoughtless. And this is really evident, I think, in the comments made by an anonymous staff member from Great Ormond Street. And so here they're talking about how it's their job to stand up for Charlie. And that what they wanted to do was give him a peaceful end. This is what they were trying to do. But what they're saying here is in the end, they weren't treating for Charlie. They weren't even doing it for his parents. They were doing it because people like Donald Trump and the Pope had suddenly weighed in as though they were experts on what was happening. And they were being called evil. That these were things that all the time, they were the ones going to the hospital and taking care of Charlie. And that they were having to do it when, with every fibre of their being, they thought it was wrong. So there isn't just a family here who is in distress, who is having a difficult time, who is navigating a complex situation. There are other people. And so we need to be mindful of that when we work out what to do. So how am I going to approach this? Well, I wanted to talk to you a little bit, for those of you who are non-lawyers, some of this would be familiar to some of you, so I won't go into it into much detail, but how the law works a bit. Because I know lots of you are not lawyers, we won't be too technical. And then I want to explain a bit more the nature of this challenge. And then, perhaps unusually, I'm going to start with why some people don't want to shift to a harm threshold. So the arguments against, a defence of the orthodoxy in a sense. And then I will make a bit of a case for a change and see where we get to. Now, one of the important things to understand about the way the law works in these situations is It conceptualized parents not as having rights, doesn't speak in terms of language of rights very much, but rather in terms of having parental responsibility. So parents must behave dutifully and take responsibility for their children. And this is enshrined in the Children Act. It's enshrined in the UN Convention on the Rights of the Child. And we see a good statement of this from Lord Fraser in Gillick, where he says, parental rights to control a child do not exist for the benefit of the parent. They exist for the benefit of the child. And they're justified only insofar as they enable the parent to perform his or her duties towards the child and towards other children. So recognizing is what the balance that parents have to strike between children. Now, the state and the court system has a number of ways in which they can address concerns about parental decisions, but fundamentally, the courts will step in and can step in when that child's welfare is engaged. So Lord Scarman expresses this well in Gillick when he says their paramount concern is the welfare of the child. And there is a principle which limits and governs the exercise of parental rights of custody and care and control, so all the things that parents have the authority to do. And he says it's perfectly consistent, this principle. And what it is that when the parental right has to be exercised in accordance with the welfare principle. And when it isn't, it can be challenged or even overridden. So this is the point at which the courts can step in. And this was affirmed in Gard, as I said. So Justice Francis affirms this and says that the court has responsibility where it needs to, in the children's best interests. Now, the courts take the approach partly based on the Children Act, and this sets out a framework via which the courts have powers to make orders that will affect parental authority and how it's exercised. And within this, there's the possibility of taking children into care. But that's not what the Children Act is entirely about. It's about many things. And the court can give leave to people to bring applications, and they can then apply the welfare test and determine what orders might be made about a child. And this was part of how Great Ormond Street made their application in that case. Now, the Children Act does set a harm threshold, but it sets it only in the context of care orders, whether or not they will take a child out of a family, essentially, and put the local authority, in some sense, having ongoing discretionary authority over them. The other way in which the court can make decisions in these cases, or at least make orders, is via what we call the inherent jurisdiction. Now, these are broader powers in the Children Act, but they're residual powers. So where the Children Act will tell them what to do, then that is what is going to apply. Now, this jurisdiction, it derives from the delegated duties of the Crown, which are about protecting citizens. That's the point of it. It is a jurisdiction the court has to protect vulnerable people. It's broad, and the courts tend to exercise it with restraint and consideration. They don't use this to step into situations and tell people what to do without good reason. And they do it lightly, with a light touch, I think. Now, the challenge to this is instead that this shouldn't be the fundamental, that it shouldn't be just welfare. There's quite a low threshold for stepping in when a child's welfare is engaged, which is, can be quite a small thing happening to the child for that to be true. Rather, if we go back to the original challenge in Gard, it is that instead, that we should take this standard, this threshold that's used in the Children Act in relation to care proceedings, care orders, and instead apply it across medical decision-making. And say, actually, parents are free unless there is this risk of significant harm being evident from their decisions. So it's an argument to increase that threshold. And they use the language of the Children Act and read across from it for various reasons that I won't go into. They don't really concern us here, because the harm threshold is one that we see elsewhere as well. You don't need to take it from the Children Act if you wanted to make this argument. People have made it elsewhere in other jurisdictions as well. So why would people not prefer moving to that? This idea that it would pull up parental rights, give a bit of authority to parents. Why would you not want to do that? Well, I think there are 4 key reasons why we wouldn't want to do that. And I'm only giving you the reasons I think are good reasons. There's lots of reasons people might say this, but these are the ones I think have quite a lot of bite. And one of them is it won't make any difference. There's no point in making a change that won't make a difference. And the reason that you might say it won't make a difference is because actually people don't bring frivolous applications. And if they do, the court has a range of ways in which it can decide it won't hear them. It doesn't have to give leave to hear these. So Rachel Taylor talks about how the court it doesn't have to hear vexatious things, it doesn't have to hear things from busybodies necessarily, it doesn't have to do that if it doesn't want to. So it can decide which cases are ones in which it should legitimately involve itself. And the tendency is, in fact, to be the ones that are serious. That's why it gets involved. And in fact, what I'd say is, in fact, often, they're the ones where there is harm on the table. There's a possibility of harm. That's usually, in fact, what might be happening. Not always, though. But one thing you might say in response to that, well, this is relying on court restraint. And this is the point that's made in Gard, in the Court of Appeal, and also I think in the Supreme Court, by Charlie's Parents' Council, is that this is all reliant on the courts deciding to behave that way. And that the law doesn't constrain them to do that, but they do it. But that doesn't mean they have to do that. So you can take your own opinion about whether or not that's a good response to that or not. And in a sense, it's almost an empirical claim, really, whether or not the courts will behave in a particular way. And people, obviously, in the debate about Charlie Gard in the public had differing opinions about this, so varying levels of knowledge about the process and so on. But the other reason is it's not necessary. And it's not necessary, some people say, because both the law and clinical practice already give enough respect to parental authority and parental interests. So Giles Birchley, who is a clinician but also a philosopher, who's done a number of studies of the way in which clinicians make decisions and parents' experience of these and so on, talks about how, well, actually what happens is that clinicians already give lots of respect to parental wishes. It isn't the case that clinicians don't listen to families and don't respect what they say. Quite the opposite. And actually, but they work with parents as far as they can. And the cases that we see coming to courts are the point at which a long process has broken down. And he demonstrates this from a number of interviews that he does. But it's also the case, I think, that the courts respect parental authority. And we can see numerous statements where they make a point of saying, we do take seriously the role of parents, the importance of parents. So you might say, well, we already give enough respect. So why would you change? And I think that's a pretty good argument, actually. That's a good one. But the third one is it doesn't actually resolve hard cases to put in place a different threshold. Now, part of that would be because the hard cases are already the ones that we're seeing coming in and looked at via best interest welfare instinct. But from a philosophical perspective, one of the objections to best interest is the idea that it's vague. What are best interests? Well, best interests are essentially a weighting of different factors and a decision about which ones are weightier than others and where the balance should be struck. And that is what a lot of the judicial exploration of this is about. How do we do that? And it's very thoughtful. But from a philosophical perspective, if there is a possibility there are multiple reasonable answers to a question, then it doesn't really tell you what to do. And so philosophers kind of object to this. I think it's problematic in some ways. And so some would argue that harm is a better threshold. It's easier to make a determination about a question of harm, and that will give you a clearer line for intervention. The point when harm is on the table, harm is a possibility, that's the intervention point. Now, whether that's convincing or not, I think is open to debate. Harm is not actually a simple concept at all. What is harm at all? Is it loss of something you had already, or is it being brought into the world with something that other people have but you don't have? Is it being brought into the world at all? Is it loss of life? Is it pain? Is it physical or just emotional? And all of these things might be clustering in there as things that it might be harming. And even if you could accurately define what harm was, it still comes down to a weighting. Many, many things that doctors do to us are in some sense harming. Every time they perform surgery, it hurts you. It cuts you open. You have to recover. But of course it's fine. It's legitimate because it is balanced. And on balance, the benefits you get from that treatment are worth it. So it may not be that it would actually resolve your question at all. It might just change the thing that you're debating about, but it might not actually resolve the answer as well as some of the proponents of the harm threshold think that it would. But the fourth really strong argument, I think, against moving to a significant harm threshold is that actually it might undermine the shared decision-making process that we see. So what happens at the moment is that clinicians will work with families and try to build consensus on what to do. And that is done where both parties are coming to the table as people who want the best for this child. That's how it's constructed. It's how the law constructs it, and that's how they construct it. Now, if instead we say parents have a trumping right, how will those conversations play out? Parents can stand on their rights. They have the declaratory power. And it's important not to underestimate the declaratory power of rights. That's why people invoke them. So they have strong power, say, it's my right. That's exactly what a lot of people in the public who are talking about this case are doing. That's why they invoke the language of parental rights. It's a trump card. Now, I think there is a real risk that if parents construct their role in this situation more overtly in rights and they are supported in it, there is a danger that it will change the way those conversation works in a way that is problematic, that will lead to less good outcomes. It's more likely to promote dispute as opposed to mediated development of a consensus view. I think that, and that's a real problem. And so if changing the framing of the law led to that, then that would be a good reason to resist it, I think. So now it sounds like I've convinced myself that we shouldn't move to the significant harm. So now let me go back to my other side of how I think. Why would I then be even considering, why would anybody be considering this? I think there's quite a few reasons for this. And one of them is that it would actually reflect the current practice. So it's the flip side of the won't make a difference argument. So actually, the argument here is it actually reflects what courts already do, and it reflects what clinicians already do. So in terms of clinicians, Giles Birchley and Dominic Wilkinson have demonstrated and made the point that actually clinicians already give a wide degree of latitude to families. And Giles' work demonstrates that actually it's quite a lot of the time doctors will do things that they might say are possibly not in a child's best interest, but there are good reasons to do them for their family. They might continue resuscitation for a little bit longer than perhaps they think is necessary because the family needs it. And a lot of other things like that they might do. But the point at which clinicians resist and stop tends to be the point at which they think they've gone beyond perhaps not in the best interest and moved into the territory of harm. So this is what Dominic Wilkinson, who's a consultant neonatologist and also a philosopher, he says that professionals tend to override parents or push to have them overridden only at the point when they think there's a real risk of harm. That's his experience of practice, and it's also his perspective from the outside as a philosopher. And I think interestingly, Jo Bridgman, who's a family lawyer, captures this in her analysis of the Guard-type cases when she says we should really understand these cases as instances of professional medical conscience. What's really going on is these are cases where doctors have been pushed to the point where they say, I do not want to do this. We tolerated some latitude, but this is the line beyond which we cannot go. And that line is a bit beyond best interest. So implicitly, you might say there's actually a harm threshold already in operation in the clinic. And you might also say that's actually the boundary that's often drawn by the courts, the point at which the court intervenes, as I've already partly explained. But I think it's interesting to see the way Rachel Taylor talks about it. She says, well, actually what we see is that the courts talk about reasonable parental behaviours. So Baroness Hale says this in Williamson when she says that the state steps in to regulate the exercise of that responsibility in the interest of children. And the state is not the child, the child is not the child of the state. And it's important that we give parents large measure of autonomy, but there are limits, and the limits are about when parents are not behaving reasonably. That's what Taylor says. She says there's lots of statements that suggest that actually the point at which the courts are prepared to intervene are the points at which there is behaviour or decisions or wishes that go beyond the reasonable and lawful approaches to a child's welfare that you would expect of parents. I think it's really important in the context of this to think about how much latitude courts actually take. I think it's really important to keep reinforcing that. So this is Mr. Justice Headley in Riel saying, look, society has to tolerate diverse standards of parenting. So the eccentric, the barely adequate, the inconsistent. And it's true that some children will experience disadvantage and some will flourish more. That's what happens. But what he's saying is that this is the consequences of us being fallible as parents. It's not the role of the courts to step in and nanny parent on behalf of parents. But at the point at which that parenting goes beyond the reasonable, Taylor says, that is the point at which you're stepping in. So you're doing more than allowing suboptimal decisions. You're actually going a bit further than that. But the question you ask then is, well, what is reasonable and what isn't reasonable? And I would say that actually analysis of the cases suggests that the point of not reasonable is actually the point of harm. Parents can be fallible. Parents can feed their children fish fingers every day for a week, and we'll tolerate that. But we won't tolerate things that are harming. That is the point at which we feel that we should step in. And that is what I think a lot of the cases reflect. And so this leads to the second argument, which is that actually we might want to say that we need to send a signal about the legitimate boundaries for state intrusion into private life. And this was a key aspect in Guard. So this is Richard Gordon QC, and he's saying, look, really the point here is that if we have best interests as the relevant touchstone, then what will happen is the distinction between legitimate state action and the discharge of parental responsibility will disappear, because anything that parents can do can just be overruled by the courts. They can step in. It's this idea that they could step in and stomp all over parents. And so he's saying, actually, we need justification before we intrude into the private sphere. And something so private as a joint parental decision. And that's what we should be thinking about here. That should be this boundary. Now, Lady Hale responds to this in the Supreme Court in Guard. And she says, well, actually, yes, she recognises that Article 8 could apply in relation to family and private rights. But she says that always, and we know this from the Strasbourg jurisprudence, that will always be resolved in favour of the child. So even if parents have rights and we should protect that privacy, we should still resolve it in favour of children. Now, I think the problem is that doesn't still give you an answer. It doesn't give you an answer to where that boundary is. And I think that's a live question. It's one that we should talk about when we come to questions. We know we need a boundary, but where should that lie? I think is a question to which we need to give attention. Now, this is the point at which I want to talk to you a bit about some of the philosophical and ethical perspectives on this boundary and why we might think about giving respect and value to parental autonomy and drawing it a little bit more tightly. Now, one of those is the idea that actually there is value in respecting parental autonomy. So part of the argument in Guard and those generally in favour of moving to a harm threshold is the idea that there should be both priority and protection for the privileged position of a parent, that a parent is in a special position in relation to the child. Now, it's not just because they are a parent. It's not just that does it. But it is the fact that very often the parent will know the child best. They know them intimately. They are well placed to know what that child's subjective preferences would be, or to extrapolate what they might be if that child were capable of expressing preferences. And they're also best placed, potentially, to understand the balance that needs to be struck within a family. So to situate that child's needs within its wider context, within a family unit. And that these are important dimensions of parental autonomy that need to be given respect. And there's also the fact that parents are deeply committed to achieving the best for their child. They are on the child's team, in a sense, always. And these are valuable things. But I think a more important aspect of this is the idea that parents need space in which to parent. They need to be able to make decisions. And they need to feel supported and respected in doing that rather than policed. This is what's important about the law, sending a message that we respect parental autonomy. People get better at expressing autonomy and acting on it when they're allowed to do it. That's what being a teenager is about. It's like taking off the training wheels and slowly getting better and making mistakes. This is what Mill talks about, is we become more autonomous and better at that when we practice. So I think there's a number of sides to that. It's also impossible to police parenting too much. But that's why the law draws particular boundaries. It involves itself in some decisions and it stays out in others. It involves itself in education and child protection in the face of serious harm, but it stays out in terms of what you feed your children for breakfast, because it can't deal with it, and also it allows for differences in view. Now, sometimes people say, well, actually, the simple thing would just be to move to harm threshold because it's consistent with the Children Act on care proceedings. And I think that's a really weak argument. Consistency for the sake of consistency is not a good way to approach things, and that's precisely because the reasons that we have that high threshold in the Children Act are very, very good reasons because of the implications of those orders. But instead, we should think about this in terms of the logic of the harm threshold in relation to medical decisions and be thinking about this parental autonomy aspect. So why would it be good to respect parental autonomy in these places? Well, I'll tell you why I think that might be the case. It's because lots of the decisions that people have to make about medical care aren't actually medical decisions. They are decisions about value. They aren't decisions where you need more information as a medic. They don't tend to be of that kind in some cases. They are, in fact, decisions about how to live a good life, how to flourish. So a trade-off between staying lucid to say goodbye to your family and having a death that is free from pain, that isn't a medical question. That is a question about how you want to end your life, what is valuable to you. It's not a medical decision whether certain risks are worth certain disbenefits. So it's not a medical question about whether or not a small chance of recovery is worth the unpleasantness of chemotherapy. That's a question of value, about how you want to live your life and the sorts of risks that you want to run for the particular costs that they carry. And these are exactly the sorts of decisions we partly see. You could construct Guard in that way if the facts were slightly different. I wouldn't see Guard in that way, but many people did see Guard as give him this tiny chance, even if it's a bit harming. Now, there's factual concerns about that we don't need to go into. But if that were the case, if there had been a tiny chance and some harm that might attend it, it would have been a question partly about value as opposed to medical knowledge. Now, that leads you to think, who then is best to make a value decision for a child? And a legitimate answer is parents, if it's a value question. Why is a doctor or a court, someone external to the situation who doesn't know this child, better placed than a parent? And this, I think, is a stronger argument for the harm threshold, is that of all the people who might make a decision about value here, the parent is as well placed, if not better placed, to make that kind of decision. But the other side to this is, and we can see this in the way in which these situations play out, is that parents are compromised in these situations. They are desperately sad, and they are desperate. And I think we can understand, particularly Gar, but also Evans, as situations in which parents are being offered hope. And we might think that that is problematic, that they are themselves vulnerable. And Jonathan Herring has written eloquently about this, that we should understand the parents in these situations as vulnerable parties as well. That is absolutely, I think, their experience of it. And so that might be a reason there to actually step in, because we might feel that we might have thought that parents can make a good value decision, but sometimes that may not be true of some parents in some situations. And so that's why I think one goes back and forth thinking what is best, because there are, as I said at the start, so many perspectives and so many complexities. And the final argument that's often put, and I also find this one quite convincing, is the idea of value pluralism, that in a democracy, we need to respect the fact that people can have different views about value. They can understand it in different ways and take different positions on it. And the way we tolerate that and the way we respect difference is allowing for people to make different decisions about these things. So now I feel like I've almost convinced myself to move to a harm threshold. So I'm going to go back to the other side. So we're going to finish on my conflict. And I'm going to tell you the three arguments that I do feel might be compelling. But these are the arguments on which I feel the least able to have an authoritative opinion. But there'll be people in the room who I genuinely think are better able to weigh in on these. And I'm very interested to hear what they have to say. And these are the particularities that give me pause. They're also, I think, partly empirical points. And they rest on what will a change actually do in practice. So one of these is, there are three of them, one of them is the impact on the way in which these situations will be managed. If we move from a system which is emphasising working out what is best for a child and building consensus, and instead move to a situation where the court has to take a position on whether or not it is permitted to override a parental decision because those parents have crossed this harm threshold, that will become the inquiry, and that is a very different inquiry to has this child's welfare been engaged and what is best for that child. But in particular, Katie Glossop and Sarah Pope make the point that it would also alter the way in which both hospitals and legal teams will have to approach these cases. So instead of having an inquisitorial process, they say, where everybody is working to work out what is best for this child, at some point it will turn into an adversarial one, they say. That once a conflict deepens, that in fact they will have to begin, instead of working towards consensus, they will instead have to begin building the case for overriding the wishes of the parents. And we see this, we've seen it in cases like REAR, that instead they will begin to have to build the evidence they're going to need to go to court and say these parents are doing something that will be harming and they need to be overridden. That will be an important change. And they rightly say that this may be harmful, it might be stigmatising, perhaps even more problematically, it will see people's positions harden earlier, and dialogue will be more difficult. Mediation will be less effective, that people will dig into their positions, and that is counterproductive. And I think that's a very valid argument. But it is also an empirical claim about the ways in which these things will play out in reality. There's also the question about, though, with this, whether or not it might be better to do that. Should we actually be taking this pushback at parents and saying, what you're doing isn't just not in their best interest. We're going to demonstrate that it is harming, so please back down. Now, you might say that might be better. It might be better for parents to be told a stronger, harsher truth. But this leads to my second point, which is we need to think about the ways in which this change in practice would affect how parents behave. So Glossop and Pope make the very valid point that actually if you knew as a parent that if you made decisions that might be constructed as harming, that it might actually change what you say you're happy with. So you might be concerned that your decisions are going to be constructed this way. So instead you might avoid disagreeing. You might acquiesce when you might have wanted to actually push back a little bit for fear that your resistance might be used against you. And REAR is a good example of where that actually to some degree happen. Where a case was built against a mother because she had resisted some treatment decisions. And I think it would be a very sad and deep irony if, in fact, we move to an approach where the very steps that parents had wanted to give them greater power actually left them more disempowered, because the implications were that they couldn't decide as they would have otherwise decided, for fear that their resistance would be built up as, in fact, they'd be used against them to construct it as harm. So I think we need to think very carefully about that. And my final thing that gives me pause is, what are the impacts on parents' feelings? So at the moment, what happens is the parents are told what you wanted wasn't in this child's best interest. That's what was said essentially in GARD. And if you read Connie Yates' statement about this, you can see that it's hurt her to be told this, because she is absolutely convinced that that is not true. And yet the message that comes back to her is, you have chosen a course, you want a thing that is not best for your child. It's exactly what she believes is not true. But imagine instead, if you weren't simply told what you want isn't best, but instead you're told what you want to do will put your child at risk of significant harm. I think that is a different statement to make to parents. And it won't just be made in the short term. It is made over the course of a court case. That's what's happening here. And I think Glossop and Pope, do a really good job when they say it's bad enough to have a court finding that what you wanted for your child is not in your child's best interest. It's worse to have a court finding that you caused your child significant harm. And Rachel Taylor, I think, rightly says this would be terribly cruel. This is potentially a terribly cruel thing to say to parents. And again, I think that's an ironic flip side to the thing that parents, like Charlie Gard's parents, want, is it may actually harm other parents when it goes against them. And I think it's important that we notice that the words we use actually make a real difference in these cases. So we shouldn't lightly brush off the fact that we might actually harm some parents if we move towards this. Okay, so I'm going to wind up and then we can have some questions. So what's my conclusion? Well, I think that harm threshold is probably more philosophically justified than not. I think that it is the right position from that perspective. I think it does reflect actual practice. And I think it probably is the way actually these cases, these are the sorts of cases that are coming, are really ones about harm. And I think a harm threshold would actually strike a more appropriate balance, be more reflective of where we think the line really ought to lie. I don't think rights talk is helpful. I don't think constructing as parental rights is a good way to look at this. I think it deepens people's harder positions. And I think we need to think really seriously about the fact that these are value decisions, and therefore we want to respect plurality of values. But I think if there is any real risk that this will be counterproductive in practice, then those reasons have to fall away. Those arguments have to yield to the fact that at the end of the day, what we're trying to do here is to strike a position that is clear, justified, but also gets to the best outcomes. And when we do that, we need to listen to doctors, medical practitioners of every kind, parents, the courts, legal practitioners. We need to listen to everybody about what will really happen if we do this. And when we make our decision, we have to reach one that achieves the best outcome for the child. Because there is a child at the heart of all of these cases. And that child is of everyone, the one who here is the most affected. But they're also the person whose voice is the only one that can't be heard. And I think we need to take very serious account of that when we decide what to do. Thank you.